Hey, it's Terry Gorry, and this is the Irish Law and Small Business Podcast. If you were bringing a personal injury claim or thinking about bringing a personal injury claim, you need to be aware of a new change that's come into the law in relation to personal injuries this week. So today is actually Valentine's Day, coincidentally, 14th of February, and today is Tuesday. Yesterday, Monday, a new act came into law in Ireland. It's called the Personal Injuries Resolution Board Act 2022. There's a couple of very important provisions in it which will affect you if you are thinking about bringing a claim or have already brought a claim and perhaps it's not settled yet or not finalised. Under the new measures, claimants who proceed with a court action after rejecting an injuries board assessment of the value of their claim will not recover their legal costs and may face paying the other side's costs if the court ultimately awards them a lower amount than the PIAB assessment. So for the sake of this video, and by way of an example, let's say your injury has been a soft tissue injury or a back injury that's relatively minor, and let's say the injuries assessment board has valued it at, let's say for the sake of argument, €10,000. If you reject that and then commence legal proceedings and go to court and you're awarded 5 or 7 grand, say, in court, then you're going to be at risk of the other side's costs. So you must beat whatever the assessment board puts on it, the value of it, if you go to court. So there's an extra element of risk there. In other words, not only will you pay your own costs, but you'll be paying the other side's costs as well if you fail to beat what the injuries board has put on it. It means as essentially that if it goes to litigation after being refused by a claimant, the PIAB assessment that has been accepted by a respondent will have the status of an offer of tender payment. So an offer of tender payment is a method by which a respondent in an injuries claim, a personal injuries action, can actually make an offer to settle the claim and lodge it in court. And if the offer of tender payment is not beaten by the claimant, then the risk of costs going the wrong way will be present. This gives a statutory basis, though, for the injuries board, their offer or their value of the claim, as it were, their value of the damage, the injury, not being beaten. Then there will be a cost situation. PIAB will also have more time. The injuries board will also have more time to assess claims where an injury has yet to settle. And obviously an injury can settle fairly quickly, or it can drag on, and the injuries board then won't have to rush into making an assessment in circumstances where it's really not appropriate if an injury has not settled and the prognosis is uncertain. The injuries board will also assess claims of a wholly psychological nature. This wasn't the case in the past. In the past, if the claim was for a psychiatric or psychological injury, then the injuries board would simply issue a letter of authorisation allowing the claimant to bring a claim through the court system. And it will also be an offence to supply false information to the injuries board, and the legislation empowers the injuries board to disclose information to An Garda Síochána. They are some of the provisions of the Act. It's the Personal Injuries Resolution Board Act 2022. Not all sections of the Act have commenced yet, but the most important one, which has commenced and commenced this week, yesterday, Monday, the 13th of February, is the one to do with the costs going against you if you refuse an injuries board assessment, go to court and fail to beat that assessment. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below. Thanks a lot.